Are you familiar with the legal concept of cause of action?
It is a fundamental concept in our rules of civil procedure, specifically under Rule 2 of the Rules of Court.
In the world of law, understanding what constitutes cause of action is crucial for both plaintiffs and defendants.
In this video, we will dive into the intricacies of cause of action,
Exploring its essential elements and significance in legal proceedings.
Backed up with interesting jurisprudence as well as practical illustrations. Join us as we uncover the fundamental principles governing this foundational aspect of civil procedure.
Section 2, Rule 2 of the Rules of Court provides that a cause of action is an act or omission by which a party violates a right of another. So what are the essential elements of a cause of action?
The Supreme Court ruled in the case of ASB Realty Corporation versus Ortigas and Company Limited Partnership. Under Section 2, Rule 2 of the Rules of Court, a cause of action is an act or omission by which a party violates the right of another. The essential elements of the cause of action are: first, a right of favor of the plaintiff by whatever means and under whatever law it arises or is created. Second, an obligation on the part of the defendant not to violate such right. And third is an act or omission on the part of the defendant in violation of the right of the plaintiff or constituting a breach of obligation on the defendant to the plaintiff for whatever the latter may maintain, an action for recovery of damages or other relief. It is only upon the occurrence of the last element that the cause of action arises, giving the plaintiff the right to file an action in court for the recovery of damages or other relief. Alan borrowed money from Ben in the amount of 5 million pesos, payable in 1 year with a legal interest rate of 2% per month. This established the existence of plaintiff's right. Alan should comply with the agreement of paying the amount loaned. This established the duty of the defendant to respect the plaintiff's right. If after 1 year, Alan failed to pay Ben as agreed upon, this constitutes omission in violation of the plaintiff's right, thereby establishing the existence of a cause of action of Ben against Alan to collect the said amount. If Ben decides to file an action against Alan for the collection of the sum of money, that gives rise to a right of action in favor of Alan. If Ben actually files the case in the court for the collection of sum of money, this is known as inaction.
A cause of action is sufficient if a valid judgment may be rendered thereon if the alleged facts are repeated. To determine the existence of a sufficient cause of action, the court takes into account the material allegations in the complaint and no other. Number 2. Whether or not admitting the facts alleged, the court could render a valid judgment in accordance with the prayer of the complaint. It was ruled in the case of Sol Oil Incorporated versus Philippine Coconut Authority that, in determining whether a complaint states a cause of action, the trial court can consider all the pleadings filed, including annexes, motions, and the evidence on record. The focus is on the sufficiency, not the veracity, of the material allegations. Moreover, the complaint does not have to establish facts proving the existence of a cause of action at the outset. This will have to be done at the trial on the merits of the case.
Failure to state a cause of action and lack of cause of action is distinct from each other. Failure to state a cause of action refers to the insufficiency of the allegations in the pleading, while lack of cause of action refers to the insufficiency of the factual basis for the action. Failure to state a cause of action may be raised at the earliest stage of the proceedings through a motion to dismiss, while dismissal for lack of cause of action may be raised at any time after the question of facts have been resolved on the basis of the stipulations, admissions, or evidence presented by the plaintiff. Dismissal for failure to state a cause of action is a dismissal of the pleadings, while the lack of cause of action is a demurrer to evidence. The Supreme Court declared in the case of Philippine American General Insurance Company Incorporated versus Sweet Lines Incorporated that before an action can properly be commenced, all the essential elements of the cause of action must be in existence. That is, the cause of action must be complete. All valid conditions precedent to the institution of the particular action, whether prescribed by statute, fixed by agreement of the parties, or implied by law, must be performed or complied with before commencing the action, unless the conduct of the adverse party has been such as to prevent or waive performance or excuse non-performance of the condition.
Cause of action was distinguished between the right of action in the case of Multi-Realty Development Corporation versus Condominium Corporation. The Supreme Court held that the term right of action is the right to commence and maintain an action. In the law of pleadings, right of action is distinguished from the cause of action in that the former is the remedial right belonging to some persons, while the latter is the formal statement of the operational facts that give rise to such remedial right. The former is a matter of right and depends on the substantive law, while the latter is a matter of statute and is governed by the law of the procedure. The right of action springs from the cause of action but does not accrue until all facts which constitute the cause of action have occurred. However, a cause of action is not enough to bring an action to court. There must be a compliance with the condition precedent. Failure to comply with condition precedent does not give rise to the right of the plaintiff to file an action with the court.
In forcible entry, 3 requisites have to be alleged for the complaint to state the cause of action and for the court to acquire jurisdiction. First, plaintiff must allege his prior physical possession of the property. Second, he must also assert that he was deprived of the possession of property either by force, intimidation, threat, strategy, or stealth. Third, he must file the action within 1 year from the deprivation of the possession of the land or building. Even if the plaintiff has a cause of action for forcible entry, if he, in his complaint, fails to allege the essential elements, his complaint will fail to state a cause of action.
Section 3, Rule 2 of the Rules of Court provides that a party may not institute more than one suit for a single cause of action. A party may not file more than one case for a single cause of action. In other words, one cause of action only allows the filing of one action.
Section 4, Rule 2 expressly prohibits the splitting of cause of action. If 2 or more suits are instituted on the basis of the same cause of action, the filing of one or a judgment upon the merits in any one is available as a ground for dismissal of the others. Splitting of cause of action is the act of dividing a single or indivisible cause of action into several parts or claims and instituting 2 or more actions upon them. A single cause of action or entire claim or demand cannot be split up or divided in order to be made the subject of 2 or more different actions. In the case of Backrach Motor versus Icaranial in 1939, the Supreme Court ruled that the rule against splitting a single cause of action is intended to prevent repeated litigation between the same parties in regard to the same subject of controversy, to protect the defendant from unnecessary vexation, and to avoid the costs and expenses incident to numerous suits. And again settled in the case of Chu versus Spouses Cunanan, the Supreme Court ruled that the petitioners were not at liberty to split their demand to enforce or rescind the deed of sale with the assumption of mortgage and to prosecute piecemeal or present only a portion of the grounds upon which a special relief was sought under the deed of sale with assumption of mortgage, and then leave the rest to be presented in another suit. Otherwise, there would be no end to litigation. Their splitting violated the policy against multiplicity of suits, whose primary objective was to avoid a unduly burdening of the dockets of the court.
In case of a loan secured by a mortgage, the creditor has a single cause of action against the debtor, and that is the recovery of the credit with execution upon the security. The creditor cannot split his single cause of action by filing a complaint on the loan and thereafter another separate complaint for foreclosure of the mortgage.
Section 5, Rule 2 of the Rules of Court provides for joiner of causes of action. A party may in one pleading assert, in the alternative or otherwise, as many causes of action as he may have against the opposing party, subject to the following conditions. First, a party joining the causes of action shall comply with the rules of joiner of parties. Second, a joiner shall not include special civil actions or actions governed by special rules. Third, where the causes of action are between the same parties but pertain to the different venues or jurisdictions, the joiner may be allowed in a regional trial court provided one of the causes of action falls within the jurisdiction of the said court and the venue lies therein. And fourth, where the claims in all the causes of action are principally for recovery of money, the aggregate amount claimed shall be the test of jurisdiction.
Anton is the debtor of Bella for 350 pesos due on January 5, 2024. Anton likewise owes Bella 350 pesos due on February 5, 2024. Both debts are evidenced by distinct promissory notes and incurred for different reasons. Anton has not paid the debts despite demand. Each debt is a separate cause of action because each is a subject of a different transaction. However, under the rule on joiner of causes of action, Bella may file a single suit against Anton for the collection of both debts, despite the claims being actually separate causes of action and having arisen out of different transactions.
Section 6, Rule 2 of the Rules of Court provides for the concept of misjoinder of causes of action. Misjoinder of causes of action is not a ground for dismissal of an action. A misjoined cause of action may, on motion of a party or on the initiative of the court, be severed and proceeded with separately. This happens when two or more causes of action are joined in one complaint when they should not have been joined.
What are the effects in case of misjoinder of causes of action? First, it is not a ground for dismissal of an action. And second, it may, on motion of a party or on the initiative of the court, be severed and proceeded with separately.
An action for forcible entry is joined in one complaint with the causes of action based on several promissory notes. The complaint should not be dismissed based on the misjoinder of the forcible entry case. Rather, the cause of action on forcible entry merely needs to be severed from the complaint and proceeded with separately in another action.
Take note that in the case of Salvador versus Patricia Incorporated, the Supreme Court held that while a disjoinder of causes of action is not a ground for dismissal, yet if the plaintiff refuses to sever the misjoined cause of action as ordered by the court, the complaint may be dismissed conformably pursuant to Section 3, Rule 17 of the Rules of Court, which allows the dismissal of a complaint for failure to comply with the order of the court.
From its definitions to its practical application, understanding cause of action empowers litigants to navigate the legal proceeding with clarity and precision.
In conclusion, our discussion through Rule 2 of the Rules of Court has underscored the importance of cause of action in civil procedure.
Don't forget to like, comment, and subscribe in this channel for more legal videos. Thank you for watching and see you again in our next video. Bye!